Hello, everyone, and welcome to another episode of the Counsel, a podcast series by Volody. I'm 𝐬𝐭'𝐬, VP of Sales at Volody, and your host for today's conversation. At Volody, we have been transforming the legal landscape since 2016 with our legal tech solutions in contract lifecycle management, litigation management, insider trading compliance, empowering the legal team with technology to drive efficiency and impact. This podcast brings you the insights from the leading legal minds, exploring their professional journeys, key learning, challenges, strategies. After all, it's not just about the law, it's about the stories behind it. Let's get started. Today, I'm delighted to welcome Sanjukta Venkatesh, Head of Legal at Nayara Energy. With over 15 years of experience, Sanjukta has built a distinguished career aligning legal strategies with business objectives, driving operational excellence. Her expertise spans risk mitigation, compliance management, stakeholder engagement, governance framework that supports the sustainable growth. Her journey began as an associate at 𝐀𝐟𝐭𝐞𝐫, followed by impact roles at ITC Limited as Senior Manager Legal, Unilever as Regional Legal Counsel, and later AVP Legal with the Godrej Group, before taking her current leadership role at Nayara Energy. Sanjukta, it's a pleasure to have you with us today. We're looking forward for an insightful conversation.
Thank you, Milind.
So, Sanjukta, what inspired you to pursue the career in law?
So actually, law was something which wasn't really something which we thought of, or something which my parents also thought that I would get into, because both of them are essentially from a science background.
Mm-hmm. Okay.
But liking for law actually came from my love for reading stories and for storytelling. So as a child in school, I used to write a lot of short stories. I used to write for the school magazine, etc. Okay. And I was always fascinated by how words are able to shape, perspectives. And then once I started growing older and once my interest in law started, developing, I realized that that's exactly what the law does. It's about basically weaving facts, circumstances, principles, arguments into a compelling narrative so that you're able to understand how the entire story unfolds. So that is what basically made me feel that maybe I can consider law as a profession, and that's how I came into law.
All right. So have you taken these, which college you joined?
So I did my graduation from West Bengal NUJS, National University of Juridical Sciences. It's one of India's premier law institutes. I was in fact the third batch. So when I joined the college was starting off under the eminent leadership of Dr. N.R. Madhava Menon, who had incidentally set up National Law School Bangalore. And then he had come to set. So this was the second national law school in the country which was set up. Okay. And therefore, since at that point of time he was the vice chancellor, it was a logical choice that you would love to benefit under his tutelage and his and his experience. So when I got through, I decided to join here.
That's interesting. So you have almost having 15 years of experience. Would like to share 15 plus year, yeah. So can you share your overview of your legal journey?
So I started off my career as an associate with law firms like Paras Quad & Associates and 𝐀𝐟𝐭𝐞𝐫. I started off doing general litigation, corporate advisory. After that, I got a chance to move in-house and I joined ITC Limited as an assistant manager to start with, and that was my first. That was where my in-house legal journey started, if you could say it. So in ITC, I joined the company at the time when many of the current businesses which you see, like the foods and the FMCG business, had all just started taking off. Okay. So I had the privilege of partnering those businesses from their inception, seeing their growth, being a part of how the business was being thought about, conceptualized, giving legal strategy at a very, very holistic and a ground level. And that's where my learning actually started. And that's how I started, realizing how vital a role law can play in directing and shaping business. After around nearly 11 years in ITC, I got an opportunity to join HUL, Hindustan Unilever, and I took up the role of their Regional Legal Counsel South. So I was handling the entire southern business of Unilever. So all their brands across all territories, I was handling around 6 states. Okay. And I was in charge of all their factories, their supply chain, litigation, contracts. Basically it was an end-to-end role for the at a regional level. After doing that for a couple of years, I got a chance to join Godrej Group. So I moved to Bombay and I joined Godrej as AVP Legal. There, my role was a little different. It was more from the point of view of advising corporate functions, leading regulatory advisory. I was also handling taxation. And then I recently got a chance to move to Nayara Energy, which was a very exciting role considering it's oil and gas and energy. It's a highly upcoming field. It is a very complex and challenging industry area to be in. And I got the benefit of getting a leadership role in this industry. So I took it up. So that's where I am right now.
Very interesting journey, actually. Most of this in manufacturing, and now you move to the oil and gas vertical.
So basically, FMCG manufacturing is a very different industry. The regulatory challenges there are very different. Compliances are very different.
Okay.
But oil and gas being even more highly regulated. So when I was in ITC, I was also involved heavily with the tobacco division. So I do have a fair bit of exposure in handling regulated high-stake industries, and that experience has greatly helped me in my present role.
Okay.
But having said that, oil and gas is a very, very different ballgame. So from a compliance point of view, from a regulatory point of view, from a decision-making point of view, and because of the nature of the product, it's extremely high value and high stake. So you have to be very, very careful in terms of how you're taking decisions, how you're advising the business. The transactions are very complex. The strategy itself requires a lot of deep diving into how the business functions and how the business works. So it's not only merely looking at the law, it's more about looking at the law from the perspective of how the business works and applying law there. So that way, while there are some, and while my previous experience has helped me, but trust me, in this role, every day is a new learning curve. So I'm learning on a daily basis as I work, and I'm guessing that's how it's going to be.
Yeah, absolutely correct. Becoming in oil and gas, basically, there will be a lot of government regulations would be there you need to follow, as well as the compliances as well.
Yeah.
And your interactions would be with the different stakeholders, external, would you have been increased as well, right?
So my role here is mostly I look after the entire domestic business of the company, which is around 70% of the company's overall, turnover and operations. So everything including B2B, B2C marketing, I oversee legal strategy for the, refining operations, managing high value disputes, retail, the entire retail infrastructure, supply chain, logistics, commercial. I am also looking after IT. So between these are the meat, like the most critical businesses and functions of the company are part of their domestic business. So that's essentially what I'm looking after.
Yeah, that's very impressive. So Sanjukta, actually, you always work with a team, actually, right? So what are the biggest challenge actually in managing the in-house legal team?
Basically, when I initially started my journey, I was part of a team.
Yeah.
And there, as a junior member of a team, your role is very different. It's very limited to only the work that you're given and coordination with other team members. When you start handling a team, you realize that the biggest challenge is balancing our role between being a guardian of compliance and an enabler of business. So business, more often than not, they want quick solutions. They want you to agree to whatever they say, largely because they want to move ahead. They want to do business. They don't want to be seen. They don't want legal to be seen as a roadblock.
Correct.
And they want you to work fast. But the idea is to ensure that while you're delivering speedy solutions, you're not sort of delivering the wrong solutions. And as far as managing a team is concerned, it's also about developing talent and helping them think beyond just the four corners of what the law says or what the statute says, but enabling them to think commercially and strategically. So different people have different skill sets, or they have different limitations. Some people find it difficult to deal with practical situations, but working in-house and advising business is all about applying the law to practice.
Correct.
So managing an in-house team means you have to teach people who cannot think practically to start thinking practically, while ensuring that they are also being compliant with the law, and they are also delivering business solutions at a reasonable speed. So I think that is the biggest challenge between following what you have been taught and executing what you're asked to do.
That is absolutely correct, actually. I mean, every field we always see that there is a vast difference in terms of what is been taught in the college and what you learn actually on the field. So as you rightly said, it's very important giving them the exposure of the practical knowledge. Yeah. It's very important. So how do you see that the role of a in-house counsel evolved over the years?
So I think initially in-house counsels were seen more as reactive advisors. So when the company would have a problem, when you would want to take any legal action, when you would have any sort of compliance issue, or you would have something, then they would typically come to the in-house legal team and ask them, I'm in this problem now, can you provide a solution? I think over the years, the role of an in-house counsel has moved more to being a proactive business partner rather than being just a reactive advisor.
Correct.
So earlier, while we were called in at the end to just tick the box and to get legal approval, I think today we are at the strategy table with business where we are actually shaping decisions. We are helping them anticipate risks. We are enabling them to think from a compliance perspective right at the very inception. So that you can take certain preventive measures at the very start, and they don't lead to a non-compliance later on. So many times you would see there would be when a legal problem comes up, you would realize that had we advised people earlier, maybe they would have taken a different decision, or they would have maybe structured things differently. So I think that is where now we are coming in. At the structuring stage, we are being asked to come in so that we can provide our inputs then, rather than merely reacting to a problem once it exists. So I think that's how the role has changed and shaped.
Absolutely. And just to add on to this question, actually, and again, managing the internal stakeholders has always been a challenge, right? Because working with the different stakeholders, sales, marketing, finance. Do you want to share some experience or any sort of basically tips actually on this?
So the thing is that when you're advising business, you have to be very cognizant about what is it that they want you to do for them. And whether that thing is a short-term impact or whether that thing will have a long-term lasting impact. Because when you're doing risk assessment and when you're doing risk management, sometimes certain decisions need to be taken keeping a short-term perspective in mind for the business. So there is always a calculated risk in any decision. But sometimes some decisions which will have a long-lasting impact, you have to take a more conservative approach and explain to them that, look, the reason why we cannot do this today is because tomorrow and 10 years down the line, you could be faced with this kind of a problem. So different divisions will have different challenges. Like finance will have a different set of challenges. They are only concerned about ensuring that their money is not blocked in any way, and that funds are not getting impacted. For marketing and sales, it's all about seizing the moment. They want to do what competition is doing. Tomorrow, like I remember in ITC, if one of the competitors would release an ad today, these guys would come that very day and say, we need to release a bigger ad tomorrow. So so you have to give whatever legal approvals need to be given because the ad has to be moved. So then there would be a fair amount of pressure from them at all times, because keeping the market, how the market is evolving, how consumers are reacting. They want to face their business strategy accordingly, and then they expect you to be able to advise them and partner them and help them out. So that's basically some of the challenges which we face.
Okay. And how you are seeing basically the technology is being used actually by you basically in the legal setup and whatever, and to get the benefit out of the solutions?
So technology, earlier technology was initially limited to say tools which would help us with case law research. But now technology is moving to from a contract lifestyle management is possibly one of the most basic kinds of technology which every company has and which every in-house legal team is required to know. Because a large volume of in-house legal work in most companies is contracts. And all companies don't necessarily have very big legal teams to handle everything manually. So that is where an effective CLM tool is very important. To be able to make your life easy, to help business as well, to be able to track the volume of contracts, to be able to track changes in the contracts, to be able to deliver new contracts with greater speed and efficiencies. These are all things which a contract management tool to help you flag risks.
Correct.
So I think that is how AI is developing, and also more from a risk anticipation perspective. There are many AI tools nowadays which we use which help us calculate and anticipate risks in advance. And I think some advanced contract management tools would be able to maybe give you that analysis as well. Like say for example, you feed in 4 types of contracts. A tool would be able to analyze a particular clause in 4 contracts and give you a breakdown of which clause is more effective from a risk management or a risk analysis perspective. So that is the extent to which now technology and AI is actually helping lawyers do their work, particularly in an in-house perspective.
Yeah, absolutely. I mean, that is very important because, of course, practical knowledge is important, of course, but that is to be backed by the technology tools that makes the life easier.
Absolutely.
So you've been into contract management for a long time. So, I
Yeah.
mean, what are your top tips for contract negotiations?
So contract negotiation, I mean, particularly when I've had dealings with legal teams from other companies or from, basically legal teams from the other side across the table. The idea is that don't just fight over clauses. Uncover the real interests. What is it that you want to achieve through this contract? Protect your risks and build a deal that is beyond a mere signature. The idea behind that most people have is we just want to close this and we want to sign the contract.
Correct.
But signing the contract is only step one. After that, you have the implementation of the contract. After that, you have all the other things that come out of the contract.
Correct.
So negotiation should keep that end game in mind rather than only focusing on closing the deal and putting pen on paper. So I think that is my main tip for contract negotiations. Don't only do what needs to be done to sign the contract, do what needs to be done to essentially fulfill the contract.
Sanjukta, thanks for sharing this information. So how do you manage the stress actually in a high pressure situations? Because I understand working internationally as well as actually in such a large organization, there will be a lot of stress situations as well. So how do you manage the stress actually?
So yeah, you're right. So stress is, I think, a daily part of every legal individual's life, particularly in an in-house perspective, and depending on the kind of industry that you're working for, the stress is more or the stress is less.
Yeah.
So managing stress is, so basically, like I said, in-house people, while obviously now our role is being shifted to more strategy and to more, advisory rather than just being reactionary. But at the end of the day, you are contacted when there is a fire.
Right.
So the idea is that to not only fight the fire, but to focus on where the fire is spreading and to what extent the fire can spread. If I may, if I can use that analogy.
Yeah, correct.
Then secondly, if you have a team, you need to stay very calm because the team takes their cue from you. So if you panic, they panic. And then once people panic, they stop being, logical and reasonable. So if you need people to be able to think logically and reasonably, you have to ensure that they're not panicking. And you may be panicking from within, but they are not supposed to see that. So you have to stay calm to ensure that they stay calm. And as you keep navigating small hurdles, then you realize that you get an idea of the bigger picture. So more often than not, because we are stressed, we don't really see what is right in front of our eyes.
Correct.
Because we are trying to look beyond. I think what you need to first see is what is right in front of your eyes that you can fix. And then once you fix that, other doors automatically open. So that's how I mostly handle stress.
Great, Aishu. That's a nice answer. So, in fact, of course, as you mentioned, basically, there is a vast difference in terms of practical and as well as what you got learn actually during your college days. Right. So, what are the essential skills lawyers or needs basically that are not been taught actually during your school or law school?
So law school basically teaches you how to read and interpret statutes and how to understand the law. What law school doesn't teach you is how to translate that knowledge into solutions which a CEO or a senior business partner can apply to their day-to-day practice. So the way law is taught in law schools in India is still very, very bookish. It doesn't teach you practical application. And that is essentially what you need when you come to work. You need to be able to apply your knowledge to the practical situation at hand and come up with the solutions. So I think that is an essential skill which is not taught in law schools, which definitely should be taught. The orientation towards law should be more from merely, more knowledge based to more application based.
Yeah. So my next question is again on the similar lines. So what advice would like to give to the aspiring lawyers and to the law students?
So my advice is that while obviously you need to know the contents of the law and you need that legal knowledge. So while you need to focus on that, you also have to understand tomorrow that when you're going to apply that knowledge to a real life situation, the application is vastly different from what the textbooks contain. So definitely know what the textbooks contain. But when you are reading those chapters, always try to think that how can I apply this information in a practical situation? What kind of a practical situation can come up tomorrow which would require me to apply this information? So always think from a practical perspective rather than from a bookish perspective.
All right, that's great. So Sanjukta, we'll move to the next section here, and here basically would like to know about any case study you think basically is important in your life. Maybe you can give a brief overview of that, the ruling of the case and implication based on the rulings. That will help us.
So then, while this podcast is being shot for Volody, essentially a contract lifecycle management solution, let me discuss a case which deals with contracts.
Okay.
So there was a case, MBL Infrastructures Limited versus Delhi Metro Rail Corporation 2018 case,
Okay.
which essentially lays down certain very prominent contractual principles which we would all need to kind of apply and work with going forward. So in this case, briefly, the facts are that Delhi Metro Rail had awarded a contract to MBL Infrastructure for construction works. The project faced certain delays on account of DMRC, that is Delhi Metro Rail's part. They didn't give certain approvals and the site handover on time. There was a certain clause in the contract which said that there would be no damages for delay. That means the contractor would not be entitled to any compensation for any delay, even if that delay was caused by DMRC. However, MBL Infrastructure still took them to court and they claimed damages under Section 55 and 73 of the Contract Act. These sections provide statutory rights to compensation for breach and delay. And DMRC obviously resisted paying these damages, citing this clause, saying you have already signed up to a clause which says that you will not get any damages in case of delay, even if that delay is on account of me.
Correct.
So the Delhi High Court, in deciding this challenge, basically had to examine whether a clause like this can override certain inherent statutory rights which every contracting individual has. So the main issues that the court brought up was, can a contractual clause in a public contract actually bar a contractor from claiming damages, even where the employer himself is at fault? Do statutory provisions under the Indian Contract Act override contractual restrictions? So basically, the law says something, the contract says something else. Do you listen to the law, or do you listen to what the contract says, or to what you have signed up for? And to what extent can parties, particularly in a case like this where there is unequal bargaining power, be held to one-sided contractual terms? And should courts actually strike down clauses that create a fundamentally unequal relationship where public authorities, who obviously are in a better bargaining position, are able to get private parties to kind of sign up to a lot of restrictive clauses which are not in their favor, simply because a public authority has a greater bargaining position like the government or a state authority like DMRC? So the key findings which the court had here was that, firstly, statutory rights cannot be waived by contracts. So if the law provides every contracting individual certain rights, those rights have to prevail over anything to the contrary that the parties may have signed on paper. Damages, Section 55 and 73, which basically talk about compensation for damage and breach, etc. These can't be ruled out through any kind of contractual provision. So you cannot enter into a contract or sign up for something to do away with a statutory right which the law provides you. Then this is particularly relevant in case of government or public sector contracts where bargaining power is unequal, and where such clauses create an imbalanced relationship between the government and private individuals. The court has said that such clauses will not be upheld. So this principle of the Delhi High Court is basically, it builds further on an earlier case of Simplex Infrastructure versus Union of India, where a similar issue had been decided, wherein there the issue was mostly in terms of how do you deal with one-sided contracts. And here the court has actually gone into further details on how these contracts are to be read and understood, whether they will prevail, or whether statutory rights will prevail, etc. And the court also said that they will distinguish between reasonable risk allocation and clauses which typically, make one party become so strong that they are not accountable at all, like it was in this DMRC case. So certain key learnings, I think, here for all lawyers and everyone who kind of negotiates contracts for their organization is that you have to balance risk allocation. So when you're drafting contracts against the government, or when you're dealing with contracts with government and other state-run agencies, you should push to move towards a fair allocation of risk. You should not ideally agree to take on all the risk or absolve the other party from all kinds of risk. Any clauses for no claims and no damages for delay should be scrutinized very carefully, and you should avoid any blanket exclusions.
Right.
And keeping in mind that the courts will always look beyond the contract and ensure equity and statutory compliance. So while you may want to agree to something just to get your company to sign the contract, you must remember that tomorrow, if that contract is called into question and it goes before a court, the court may not uphold that contract. So you need to be very sure that when you're signing a contract, you're signing something which is going to stand the test of time. Which brings me back to my earlier thing that I said, that don't only negotiate to put pen on paper, negotiate to see a contract actually, come to its reasonable end. So that's basically what this case said and what this case was about.
All right, this is very interesting actually. I mean, a lot of again, it talks about more about basically practical situation where you have encountered such kind of thing, and how do you do that actually? How do you do that? I hope this will be useful to the audience as well.
Right.
All right, we'll move to the next final round where we are talking about the rapid fire question.
Okay.
Okay, and let's get started. So what's the one word that comes in mind when I say contracts?
Balance.
Okay. What's the biggest myth about being an in-house lawyer?
That we always say no.
What's the most rewarding part of your job?
Seeing complex problems dissolve into simple solutions.
Great. If you could change one law, which one would it be?
Succession.
Okay.
Law of succession.
What one word you would use to describe your legal team?
Proactive.
Okay. How do you balance the risk management with the business growth?
Tread cautiously, but don't remain stagnant.
Okay. What's your top tips for improving the negotiation skills?
Know when to stay quiet.
Okay. How do you deal with the competing priorities?
Always assess risk.
Okay.
And always look for long-term solutions.
Okay. What one thing do you think AI can never replace in legal work?
Human intuition.
All right, great. And how do you define the leadership in legal context?
Leadership in legal context is about enabling people who work with you to give their best and praising people publicly, but always keeping criticism private.
Okay. One last question. Which industry trend excites you the most?
I think AI, automation, artificial intelligence, technology, because this is typically what is going to shape the future, and we all need to have an eye on that in order to remain ahead of the curve.
Absolutely correct. So thank you, Sanjukta, so much for sharing your insights with us today. Is there anything else you would like to add before we wrap up?
No, that's fine. Thank you, Milind. Thank you for the opportunity.
Thank you very much.
It was great interacting with you.